As we stated, some debts cannot be forgiven through the bankruptcy process. These include those debts incurred or tainted by fraud in any fashion. Likewise, those debts resulting from willful conduct such as assault, theft, DUI, or other types of actions cannot be discharged. Many state, local, and federal taxes cannot be discharged. Some can, however, and if you have tax problems, you may want to spend extra time talking with us about them. Likewise, bankruptcy cannot alleviate family-related responsibilities, including child support or alimony-type payments. Neither can student loans be discharged, except in very rare hardship cases. If you have recently purchased luxury items or a vacation on credit, such resulting debts may also not be dischargeable. Aside from the debts specifically accepted from discharge, it is possible to lose your entire discharge so that no debts will be discharged. This can result from dishonesty associated with the process, including insufficient paperwork, deceiving a creditor, the trustee, or any other court officer. If you have hidden, transferred, or destroyed assets or records, the court may take away your discharge. Additionally, if you cannot explain what has happened to assets you used to have, you may jeopardize your discharge. Please don't think that no one will find out about your past dealings. In this electronic age, such information is readily available to trustees and creditors. Again, explaining a difficult situation to your lawyer will not put matters any more at risk. It will only help your lawyer advise you about what you can legally do. Additionally, failure to complete a personal management course will lead to a denial of discharge. Bankruptcy allows you to keep certain important and necessary assets through an exemption process. A homestead exemption is usually offered, depending on your situation, which we will discuss with you. If you are behind on house payments, you will have to find a way to catch up. Beyond that, there are allowed exemptions up to a certain value for automobiles, clothing, furniture, and tools of your trade. IRAs and federally chartered pension plans are usually 100% exempt. There may be many other exemption rights you have, and we can determine them only after full disclosure of your assets to us. Who is the trustee, and what is his or her role in the bankruptcy process? Trustees are independent businessmen and women, generally with excellent financial training and backgrounds. They are appointed to the local panel of trustees by the U.S. Department of Justice in Washington, D.C. after an extensive FBI background check. They are the watchdogs of the bankruptcy system and often hire lawyers to help them do their jobs. Trustees are regularly audited and have quite a knack for their jobs. You cannot fool them. They are good at what they do. It is their primary duty to find non-exempt assets to liquidate so creditors may be paid. If they find you have fudged on answers or otherwise been dishonest, they can seek to have your discharge denied or even revoked if such information first comes to light several years after the fact. The trustee searches out non-exempt assets and finds ways to turn them into cash. Next, the trustee reviews all creditor claims submitted to make sure no creditor is taking advantage of the situation. Finally, the trustee pays a dividend to creditors based on funds on hand versus the total amount of claims on file. Trustees also look for payments made before the bankruptcy to preferred creditors. These include payments or transfers to certain creditors within 90 days. In the case of related or insider creditors, the 90-day period is extended, so if you paid off your favorite creditor within 90 days of your bankruptcy, or if you paid off your debt to Uncle John, the creditor or Uncle John may have to give the money back, even if it was legitimately owed. Likewise, if property was transferred even as long as 4 years ago for less than fair consideration, the trustee can reverse such transfers as fraudulent. You are required to disclose such transfers or payments in your schedules and statements. The failure to do so may put your discharge at risk. You may be tempted to think that the trustee or creditors may never find out information about hidden or transferred assets or about other things you do not wish to have discovered. Keep in mind that trustees are often approached by unhappy creditors, former friends, or even family members with important information. And even when that does not occur voluntarily, the trustee may force disclosure of such information by examination under oath of such people who may be aware of your financial dealings. Keeping such secrets from the court is perjury. Oftentimes, bankruptcy is a positive step toward credit reestablishment. Although a bankruptcy will stay on your credit record for 7 to 10 years, most of our clients find they can reestablish credit in a relatively short period of time after bankruptcy. This is primarily due to the fact that most credit scores immediately improve upon the bankruptcy filing. Since the credit score is 1/3 based upon the outstanding debt versus available credit ratio, by eliminating this ratio, anyone with bad credit will see an immediate increase in their FICO score. It is not uncommon to receive credit card applications immediately upon the filing of your case. Local car dealerships actively solicit individuals with a recent bankruptcy filing. Even more importantly, our affiliate real estate companies, First Platinum Properties and First Platinum Financial, can also help you with the search and funding of your new home, 100% financing with no money down as soon as you receive your discharge. The attorney will talk with you further about life and credit after your bankruptcy filing. We will be happy to discuss what it will cost you to file bankruptcy. We will need our fees paid prior to filing your petition. In the majority of cases, this fee should be all that is necessary. However, if there are unexpected actions such as attacks on discharge, motions for stay relief, objections to exemptions, and the like, it may be necessary for additional fees to be paid. As you can see, bankruptcy can provide a fresh start for honest debtors after a rough ride.